In Chapter 4, we read about alternative dispute resolutions, otherwise known as ADR. They are described as ways to resolve legal disputes through methods other than litigation. Some of those methods are negotiation and settlement, arbitration, mediation, private trials, mini trials, summary jury trials, and early neutral case evaluation. So the chapter goes through each of those various areas, describing the particular area, the pros and cons, some of the common uses. Two of the areas that seemed to be really focused on were mediation and arbitration. And with mediation, that is where the disputant parties select a neutral party to help them reconcile their differences by facilitating communication and suggesting ways to resolve their problems. While I haven't had experience in a court situation with this, as a child care director, there are some families that I have had experience with mediation in especially divorce situations. In the state of Connecticut, if a family is going through a divorce situation and there are children involved, then part of what they are required to do is go through mediation. And part of that is to help them establish some parameters around visitations and that type of arrangement. And so as I was reading this, I was in my mind kind of going over some of the things that I have heard from families as they have gone through that process. Um, so as we ended part of the chapter, it talked about the difference between it being court ordered or being voluntary. And in this particular situation, it is a court ordered situation normally. And I think that the book is absolutely right that in that kind of situation, many families are just looking at this as just a hurdle, a stepping stone to get to the next phase, where if it is a situation where two parties are really hoping to come together to work out a situation, I think both parties would definitely be more open to actually working out the dispute and discussing those situations. So I would definitely agree, though I haven't had that experience myself. In the experiences that I have been privy to through discussion, I would definitely agree with the book that it just makes more sense that when somebody is telling you you have to do something, you're probably not as open to doing it as if you made that decision on your own. In regards to arbitration, that is where the disputing parties submit their disagreement to a mutually agreed upon person, and the decision of that arbitrator is binding on both parties. Again, while I have not personally had this experience, my husband does work for a large company who goes through union contracts, that type of thing. While that doesn't necessarily directly affect him, certainly we are aware of those going ons and the proceedings. And they have had to utilize arbitrators in the past for decision making because both parties could not come to a mutually agreed upon uh, compromise to settle a dispute and move forward. Um, so again, I haven't had direct experience, but I have, read about and been aware of situations where arbitrators have been used. And um, the book also talks about how the arbitrator's decisions are binding. There are few reasons why those decisions can be set aside, which again the book has outlined. Um, and then really the next few items that the book goes through are kind of I guess, quicker. I really felt like there was more focus put on the mediation and the arbitration, probably because those are the two most commonly used. There does seem to be a rise in some of the other things, such as mini trials that the book has gone into, and early neutral case evaluations, private trials, and summary jury trials. One of the things that I thought was very interesting from the summary jury trial was that um, the verdicts there are only advisory, and if parties don't settle the case, it then does go to trial, but then nothing from the summary trial that has come forward is admissible as evidence. So I thought that was very interesting, that that information could not then be used or would not be admissible in the court. And again, at the end, the book touches upon, the difference between, things that are court ordered versus voluntary, and the differences between both of those, especially in regards to arbitration and mediation. Thank you.